Please state your name for the record.
Thank you, Mr. Chairman. Committee members, my name is Laura Tamez, and I am the Vice President of Legislative Affairs for Texas Trial Lawyers. I am here individually and on their behalf to testify on the bill. I would like to address punitive damages and the practical effect of HB19 as it relates to more of these cases now living in a second trial where there's gross negligence and companies being more exposed to punitive damage awards. So because there's an increased risk of a company being exposed to a punitive damage award due to every pretty much negligence claim against the company for its bad conduct, then companies need to assess whether their current insurance policies cover punitive damage awards or if they need to buy more products, more maybe punitive damage policies that aren't necessarily covered, because there is the risk of not just compensatory damages, but punitives. The Texas Supreme Court did address a policy question on this. It was 2008, and the question was, does Texas public policy prohibit a liability insurance carrier from covering an award for punitive damages imposed on its insured because of gross negligence? The Texas Supreme Court said, you know what, it's going to depend on, number one, does the policy on its face cover punitives? And number two, what are the circumstances of that case? So there may be litigation about coverage for punitive damage awards. And more importantly, in 2017 in San Antonio, my town, the Fourth Court of Appeals came up with an opinion in an auto pedestrian crash that a personal auto policy did cover the compensatory damages, but did not cover the punitive damages in that case. So if the practical effect is to try and reduce insurance premiums, then it does need to be studied whether that helps companies or do they have to buy more policies.
Okay, thank you very much. Any questions? Witness? Senator West.
A couple of questions. As it relates to, and I understand there's been a lot of negotiations on this particular bill, what evidence under subchapter C, all that was negotiated, heretofore, what type of evidence would have been available at the first phase of the trial under Chapter 72?
After the negotiation?
Before the negotiation.
Before the negotiation. Pretty much the trucking company's conduct in terms of supervision, hiring, retention of maybe a driver who has repeated convictions of speeding, pretty much a company's failure to monitor. It just goes to the divisible negligence claim of a trucking company.
When you said divisible negligence claim, what do you mean?
Right. So there is the driver's negligent operation of the vehicle. That is one claim. And then under current law, there is claims that are independent against the trucking company for supervision, hiring, retention, and those are separate and distinct claims of negligence.
So when I have to explain this bill, assuming its passage, under this particular bill, if you have a stipulation by the employer and there's an issue concerning negligent entrustment, then the only evidence that you can present concerning negligent entrustment is found in subchapter C. Is that correct?
Yes, Senator.
And you can also have independent claims against the trucking company in phase one, other than negligent entrustment, right?
That is not the only claim under the bill that we have seen is negligent entrustment.
Okay, and then maybe I'm looking at, you don't have it in front of you, it's page 9 of the committee substitute, line 16. It says, nothing in this section prevents a claimant from pursuing an ordinary negligence claim against an employer defended for a claim such as negligent maintenance. So that's an independent claim.
That's an independent claim for negligent maintenance of the actual truck
So you can
Like
assert
breaks.
Right. You can assert that in the first phase of the trial.
That is correct, Senator.
Okay, that can be taken into consideration under the comparative negligence of all of the parties in this case, right?
That the negligent maintenance of the truck can be taken into consideration against the trucking company or the employer in this case.
Okay, but the way that it reads, and again, I want to stay here for 1 second so I can certainly understand this. I'm going to have to explain it because I'm going to have to explain it. This language is saying that you can bring in an independent claim against an employer defendant for a claim such as, and it gives an example.
Correct.
Correct?
Correct.
I just want to make sure. Thank you.
That is correct.
All right, any other questions for this witness? All right, thank you very much. Craig Eiland, Texas Trial Lawyers, please come up, and you're registered as against the bill.
Thank you, Mr. Chairman. Craig Eiland for Texas Trial Lawyers, and you can change my registration to on the bill instead of against the bill.
Okay, I'm going to change it in front of everybody.
Members, I want to just let you know that as the bill came out of the House, after we've worked with and against TLR throughout this session on this bill, and with members of the House, and as it came out of the House, we agreed not to seek any changes in the Senate, and we still maintain by that position. We think that it got substantially better as it left the House floor than when it came out of committee. There are a few issues that I want to bring up to your attention, and there are a few changes that we still have questions about. Number one, over on the section where you're talking about admissibility of photographs, there's been something added that says an expert can be called to testify about the authentication of a photograph. As we understand it, that's so that if there has been digital manipulation of the photograph, you could have an expert come in. We don't believe that word authentication is the proper use. We understand what they want to allow, but authentication is when somebody at the scene of an accident says, yes, this photograph accurately depicts the scene of the crash or the condition of the vehicles. An expert who was not at the accident scene right now cannot authenticate photograph. It's a minor issue, but it's one that we think probably ought to be addressed. Second, something I believe is going to happen in the future is a company will come in and, to get the benefits of the bill, stipulate the course and scope so that they get the benefit of the bill. But I think in many cases, we're going to have a sideshow of the insurance company coming in saying, this driver is not in the course and scope of employment under our policy. And so now because you can have a deviation of course and scope, you stop and go to the bar, and then you get back in your commercial vehicle and go home. That's a deviation, but the company may want to get the benefit of the bill, so they'll stipulate. That's just something I think we'll have to deal with later. And the last thing I'll bring up, unless you want to ask me some questions, is in 95 we had big tort reform. In 2003, many of us were here and had another round of big tort reform. And in that round, there was comparative responsibility. And the big mantra was we want everybody that had anything to do with the accident to be submitted to the jury so the jury can assess their conduct, right? Whether they're bankrupt, whether they're a felon, whether they're out of state and not subject to this jurisdiction, we want them submitted to the jury so they can be considered. And this is the first exception. So now we're not going, if a trucking company stipulates the course and scope, their conduct is not going to be submitted to the jury every time. This is the first exception, so don't be surprised when other industries come next session to try to get an exception for them if they stipulate the course and scope.
All right, thank you. Any questions?
I have a question.
Senator Hinojosa.
Yeah, well, exceptions, that issue is brought up almost every session on different legislation, as you well know, but you serve here in the legislature. But the comment you made about the course and scope where the employer admits the responsibility, then you say that the insurance company comes in and disavows course and scope being covered by the policy. I mean, can you explain that? How does it work?
Right. So most insurance policies will define who's covered under the policy, and they're covered while they're in the course and scope of employment. And there's a definition in the policy about what that is, right? So there is no proof required by the employer under this bill that the driver was actually in the course and scope. If the employer comes in and stipulates to course and scope, that's the end of the issue. Doesn't matter if they really were or really weren't. And there's a benefit to stipulating the course and scope under the bill. So that is just, does not have to be a factual basis.
So what does the insurance company have to do with it? I mean,
Well, so the insurance company is only going to cover drivers that are actually in the course and scope of employment based upon the facts, not based upon a stipulation by the trucking company to get the benefits of a bill.
So
The trucking company would still have to pay, okay, but insurance coverage may not be available.
but that's an issue between the trucking company and the insurance company.
It is unless they're broke, and then it's going to be an issue for the victim.
Well, I mean, that's just the way the economy is and businesses are. Some businesses do go bankrupt.
Right.
But I guess I was just trying to get a better understanding of that. So that actually this will become an issue during the trial. If the employer admits course and scope,
Right.
it becomes maybe an issue for the trucking company, the employer, down the line if the insurance disavows that there was no evidence to show that the driver was negligent and under the scope and course of the
Right.
ignition. Okay. And then just on comparative responsibility, are you saying that, I guess in the past and under tort reform bills that we considered here, we would throw all those issues and let the jury decide? Well, and here we try to focus on the actual parties involved and the driver, the employer.
Well, if the employer stipulates to course and scope, then, as Senator West pointed out, you may only introduce evidence against the company as delineated in C and that laundry list of statutes. If you can't fit your claim against the trucking company under one of those violations of one of those codes, then you can't talk about it in Phase 1.
But you can talk about it in Phase 2.
If you talk about it in Phase 2.
Okay, thank you.
And Senator West, to answer one of your questions. Oh.
Thank you, Mr. Chairman. Representatives, good to see you. You raised a couple of points I had notes on. I want to make sure, nothing other than just my clarification. I have clients that do have trucking companies. Some of them have leased with owner-operators. They run a fleet that's not theirs, but and then they have employees that have trucks that they own and drive. So does it cover the owner-operator contracted person? Does this bill cover that issue?
Yes,
so
it does.
that contractual arrangement with that owner-operator that's doing his own thing, but that's covered underneath.
Yes, because there's a language in, I think it's 053, that talks about employees that are deemed employees. And under the federal regulations, those owner-operators are deemed employees.
So the scope issue you raised is kind of covers those guys for sure. Secondly, it's a bigger conversation. It's not part of today's real conversation, but you're in this business. That's fair to say.
Yes.
And you're sharp and you know what you're doing, but can you just give me a rule of thumb? How many of these go to court? And I'll tell you the objective. If insurance companies were actually pursuing and pushing back and doing their jobs on these frivolousness, is that not part of that conversation? Because the last witness raises the issue, we're going to have to buy more insurance. Well, part of the goal is not to have to pay for more higher insurance. So I think that was relevant conversation. I think there's culprits along the way. There's bad actors, right, that do frivolous lawsuits. But we got insurance companies that it's cheaper to write a check than it is to pursue the frivolous and shut you guys down. That's just how I see it. I've seen it in practice. So when we leave here today with the bill, I'm pretty certain, moving, I want the insurance companies to hear this really clear. This is not an opportunity to go out and get more money. At the same time, not do your job on defending good actors. Because if they were defending good actors with vigorous, a large part of your industry groups don't have the resources, time, or energy to do that, and they would stop doing it. At least that's been my understanding when I see what happens in my client base of 1,200 clients. That a lot of them just get insurance companies that write checks, say, you're innocent, we know that, but we're not willing to go through the pain to prove it, and it's cheaper for us to write the check. So whoever the insurance guy was a while ago, it's not just this industry, it's E&O for service industry, it's every industry, I see it. It's just cheaper to write a check and walk away, and then they pass that on to the good actors. So there's several stools in this, and I'm supportive. I think this is necessary, unfortunately, because some of you guys are really reputable, and I think you're in that group that really try to punish the bad guys and protect the good guys. But at the same time, insurance get a walk, and have gotten a walk for a long time, because they get to just raise the cost. They don't really care what the settlement is, right? And if they don't have to spend a year in the trial, they're good. And that's got to stop too. So I say that that's a soapbox. So how many years guys go to court out of 100 cases? What do you think is going to go to court?
I think that before COVID,
just take COVID out.
About 5% of all cases go to trial.
So 95% is cut to a check from an insurance company usually that says it's just not worth our time, and that has to be a component of the cost driver of insurance that nobody wants to say, but I'll say it because that's what I see. I've got clients that quit taking insurance, not in the trucking business, because it's like if I don't have insurance, the guys don't sue because they can't get nothing. Cut it to your point.
Yeah, Chairman Smithy did put an amendment on in the House that requires a study over a 6-year period to determine if this has any impact at all on rates.
All right, Senator West.
Just quickly, Greg, as it relates to the issue that you said may be coming up concerning course and scope down the road, isn't it a true statement that insurance companies normally pick the attorneys that will be representing the insured?
Yes.
Okay, so the issue of number one, stipulating, would be made by obviously the trucking company in conjunction with its attorney, who's been hired by the insurance company.
Yeah, but in that situation, allegedly the lawyer represents the trucking company.
Normally, you said allegedly.
Well,
okay.
They know who hires them every time. But there is always an ability for an insurance company to defend under reservation of rights.
That's what I was getting ready to get to. Right. Okay. So that's a possibility that they may end up being a reservation of rights issue. Again, the comparative negligent issue and what the jury gets to apportion in the first phase of the trial. That's where I am. Okay?
Yes.
Now, negligent entrustment is now being, in terms of the evidence that the jury gets to hear, is under C.
Yes.
That's just one cause of action against a trucking company, correct?
Yes.
Obviously, you got the cause of action against the employee. There may be products liability, yada, 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 yada. But in Section F, on page 9, again, there's nothing, I'm saying page 9, it's DEF.
Yep. Yes.
There's nothing that would prevent a plaintiff from filing other causes against the trucking company, correct?
Correct.
Okay, like maintenance and any other, and I don't know all of the different causes that would normally be
Maintenance,
filed.
loading, improperly load the truck,
So all those can still be filed.
fail to maintain the brakes. Yes, that's all an independent claim
Against the trucking company, right. And so if it's an issue concerning negligent entrustment, then that's one thing, and this is the evidence under C that can be used to establish negligent entrustment.
Correct.
But the whole, I guess you could say, portfolio of evidence that's currently available under the rules of evidence can be used against a trucking company for other independent causes of actions that would fall under F.
Correct.
And so therefore, if they're independent causes of actions other than and negligent entrustment and during the first phase, all of those can still be submitted to the jury. And the jury can make a determination. The only exception, as I see in this particular bill, is the type of evidence that can, in fact, be utilized to establish negligent entrustment. Correct me where I'm wrong.
You are correct. And in C, if you have to fit any claim for negligent entrustment under one of those specified statutes. If you have evidence of some other type of negligent entrustment, but you can't fit it under one of those statutes, you cannot admit it.
And so C was tough. It was tough negotiation, right?
Yes.
Okay. But other causes of action can, in fact, be filed against trucking companies
Yes.
and get before jury for purposes of apportionment of negligence, correct?
Phase 1.
Phase 1. All right. Thanks.
Thank you. Well,
Senator Anhosa.
just a final question. But also, if I understand correctly from the question from Senator West, on the second page of the trial, you also have a list of all the different possible causes of action or evidence can be added on Chapter 41.
Yes.
Okay.
And there's two other things that we discussed with Chairman Taylor about some dates, some days, 180 days and 90 days that were not in House version, and we want to continue to work on that because we think that should be a longer look-back period instead of 90 and 100 days, which everybody admits is arbitrary. We think it should be either 1 year or 2 years.
Okay. Any other questions? Thank you very much. Call it Jim Perdue, Texas Trial Lawyers. Please state your name for the record.
Good morning. My name is Jim Perdue, Jr. I'm president of the Texas Trial Lawyers Association. I'm here on their behalf and myself, and I'm testifying on the bill. Chairman and Senators, let me begin by thanking Senator Taylor for working with us. I've had the pleasure of working with counterparties on a variety of legislation this session, worked through Senator Hancock's office on the COVID liability bill, confronted this bill. This bill was negotiated extensively on the House side. That negotiation continued on the day that this bill was voted on the House side. Those negotiations were actually occurring on the day of, and this engrossed bill comes over. And since it's come over, those negotiations have re-engaged, and thank you, Senator Taylor, for allowing us in and being a part of them. Thank you, Senator West, for facilitating that. And I'm here on the bill because while this bill and this legal proposition reflected in this bill, we don't think solves the issue which today has been verbalized as insurance rates as efficiently, Senator Perry, as you raise and could be. But we do think that the end product at least represents some balance between the concerns of industry and the concerns of the people who are injured and have loved ones lost at the hands of industry. That's a difficult balance to reach. It's a difficult balance for you as legislators to write. And Senator West, as to some of your statements today, what the main concern of the negotiation is to get something that is the law reflecting the will of the people, that is not created by the court system. And that requires careful drafting. It's the reason why there's a committee amendment to fix a couple predicates that in A and B. This was referenced to you by Mr. Parsley that are needed to kind of conform this language. But Senator West, let me at least answer one question. The definition of commercial motor vehicle in the bill is not the definition of commercial motor vehicle as it relates to the Texas Transportation Code. And therefore, when you read 054C, Senator, those are tied to the federal motor regulations, which are interstate trucks, then embodied in Texas law through the Department of Transportation Commissioner. Those are tied to curb weights. Those are tied to gross vehicle weights. This bill contemplates that an F-150 owned and operated by for a commercial purpose is a commercial motor vehicle. It is not subject to those same regulations. So in answer to your question, there are a variety of regulations listed and identified in the bill that may not govern Joe's landscaping service or Mary's transportation or delivery service. And I just wanted to make that clear since you had asked it, Senator. With that, I'm available for any questions.
All right. Any questions, members?
So,
Senator West.
so the group that you just mentioned would not be covered by the limitation of evidence under C.
So, as correctly pointed out to you by Mr. Parsley, there is 053, which is rules and regulations that are not tethered to the definition in C, which is FMCSA and text.
No idea what you're saying.
Federal Motor Carrier Safety Act. Senator Hancock is nodding his head, and I'm speaking a different code, and I apologize. I'm here to talk to the engineers today, I think, as opposed to the lawyer. But the lawyer in me would say that's the Federal Motor Carrier Safety Act. Those are the regulations for trucks that are subject to interstate commerce. And then those are incorporated into Texas law based on...
Chapter 644.
Yes, sir. Yes, sir.
So this bill is for the big dogs.
Yes, sir. That section of the bill is for the big dogs.
Well, I mean, the reality is that what we're saying, members, is that only the big dogs get the benefit of limitation of evidence and negligent entrustment causes under Section 3.
Yes, sir.
Am I right or wrong about that?
You're right, because
so little dogs don't get the benefit of this.
Well, the question that will be litigated is if there is an entrustment question and there is not a defined regulatory standard, for example, on drug testing, and you put a driver behind the wheel of an F-150 who's been on work for 24 hours or driven continuously for 14 hours or had a positive drug test in the last 30 days, all of which would take you out of service under the federal regs, but you're not subject to it as a small company, what does that do? That doesn't fall under the C.
Well, and members, I'm not, Mr. Chairman, I'm not trying to, Senator Taylor, if this is going to be for the trucking industry, the question is who's regulated? The only way you get the benefit of this is that if you're regulated under one of these statutes, as I understand it, and if you're not regulated under one of these statutes, then you don't get the benefit of it. Correct me if I'm wrong.
That's the way I read, but Senator West, I want to be committed to our word. And when this negotiation was occurring in the House, we were committed to stand by it. This was not our prescription. The bill itself is not our prescription, but I'm not going to back away from that commitment.
Well, I mean, members, this is for the big dogs now. I mean, if you look at it, you got to be regulated under these two statutes, and I understand that's basically the ones that are interstate commerce, which is 18-wheelers.
Yes, sir. It's curb weight.
Senator Hancock.
And I think just clarification, same company has Salesforce driving company vehicles, sedans, whatever. They also have freight that they ship. They've got the big rigs. Those are covered. This bill addresses them completely separately. One, you're covered. You got to follow all the 49 CFR guidelines, all the federal guidelines. The other one, for those sales vehicles, there's just not a whole lot of federal regulations over those. You get them a car, you put them in it, and they're going. In this bill, it addresses them. Same company could have the same. Both could have accidents, but they're addressed differently in this bill.
I believe so, Senator. I mean, you have vehicles that require a commercial motor vehicle license, and you have vehicles that don't.
That standards pre-hiring before you put somebody in the back behind the steering wheel of one of them, a lot of regulations, a lot of requirements. The other one, it's basically tell them to go get what they want and put them behind there, and there's not a whole lot of training or regulations.
Yes, sir.
All right. And then one of the freight companies as well, because of the 180 days and 90 days that Representative Eiland brought up, there are different guidelines on how training has to take place, and I think that could have an impact on those date times to make sure that you look at the full scope of the company to make sure that those training guidelines were consistently followed within a period of time. So I think that's why the 90 days and 180 days needs to be looked at, because there are requirements of certain time frames of when training must occur, and you could miss out on some of that to see if that was consistently done throughout a year. So something to look at as well.
And we, as we have before, hopefully with Senator Taylor's, we will certainly be engaged in that to try to come up with appropriate solutions, Senator, and we'll make that commitment.
All right, thank you. Any more questions? Thank you very much for your testimony.